Every day in the USA, people find themselves in court.
Good morning.
Are
Good
you,
morning, Judge.
good morning. Are you Martin Casada?
Yes, ma'am. That'd be me.
Okay, Mr. Casada, I have a felony complaint that I need to arraign you on. The allegations of that order about August 30th, 2025 at 3900 Burnway Drive, apartment 206, Lansing, Michigan 48911, that you did allegedly attempt to commit the following said offense, and in the attempt did act towards the commission of that offense. That is an attempted home invasion third degree, allegedly having failed to in the perpetuation or the was prevented in the execution thereof, and contrary to MCL 750.92. The allegations that you did allegedly attempt to break and enter, or did enter without permission, a dwelling at 3900 Burnway Drive, apartment 206, while entering, present in, or exiting the dwelling, did commit a malicious destruction of a building less than $200, which is a misdemeanor, contrary to MCL 750.11A4. Count one, attempted home invasion third degree, however, is a felony. And so the maximum penalty that you're facing in count one is 2.5 years in prison and or $1,000 in fines. Court shall order law enforcement to collect the DNA identification profiling sample. Count two is malicious destruction of a building less than 200, alleging that on or about August 30th, 2025, at the same address, 3900 Burnway Drive, apartment 206, in Lansing, Ingham County, that you did willfully and maliciously destroy or injure a building or its appurtenances located at 3900 Burnway Drive, apartment 206, that belonged to a Joe L.F. Chambers, and that the amount of the destruction or injury was less than $200, contrary to MTL 750.380. Count two is a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, or 3 times the amount of this destruction, whichever is greater. However, sir, you are being charged as an habitual offender. Third offense notice. It says here, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony in that order about January 28th, 1998. He was convicted of the offense of carrying a concealed weapon. Are you okay, sir?
Yes, ma'am.
Okay.
I mean, ma'am, I'm just, I know you're reading my charge and everything, but what this lady is trying to say,
Martin,
is not what happened.
Martin,
And
Martin,
I'm gonna establish that because the simple fact, hold on, Trey.
No, you hold on. Listen,
Stop right now, because they're going to tell you to stop talking because it's not your time to talk. After today's only for your arraignment, sir, not to argue.
I'm not arguing, sir. I'm just letting her know that all these.
I can move on. I can move on. You know, this is Saturday. I worked all week. If you don't want me to do your arraignment, you can sit tight until Tuesday when we come back in here. Okay?
Ma'am, I'm not disputing that. I'm just trying to explain to you what happened.
Did I ask for your explanation?
No, you didn't.
Okay, I asked you were you okay, because as I'm trying to read your charges to you, you were turning around as if something was wrong. And so if everything is okay and you're ready to proceed, then you remain quiet while I read the charges, and I will stop periodically to ask you if you understand or have questions about the charges and or your rights. But this is not an opportunity for you to present any defenses. Do you understand that?
Okay, thank you.
Your attorney, Mr. Ned, placed an appearance on the record on your behalf, and he's trying to counsel you because you have the right to remain silent, and anything that you say can be used against you. So he doesn't want you speaking or blurting out on the record without being properly counseled. Do you understand that?
I understand it, Mr. Judge.
Because you may say something that places you at the location, and that could be used against you. So learn to follow instruction, and when your attorney tells you to be quiet, do it. Okay. You are being charged as an habitual offender. Third offense notice. It says, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony in that order about January 28, 1998. He was convicted of the offense of carrying a concealed weapon under MCL 750.227 in the 30th Circuit Court, Ingham County, state of Michigan. And that order about January 28, 1998, he was convicted of the offense of operating while intoxicated, third offense, in violation of MCL 257.6256D in the 30th Circuit. And therefore, the defendant is subject to enhanced penalties. That enhances your penalty under MCL 769.11 to twice the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. Do you understand the charge that was read and the maximum penalty as well as the habitual offender third offense notice, sir?
Yes, I do, Judge.
Okay, you have the right to remain silent. Anything that you say can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way through the prosecution up to a jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty, and you can take this matter to trial, but you have the right before that to have a preliminary examination on count one because it is a felony. You have the right to have that preliminary examination within 21 days of today's date. You have the right to require the prosecutor establish on the record sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. Do you have any questions so far?
Come on.
Let me just interrupt. I don't think I received any criminal history for him either. Okay, I'm not sure why this is the second file I don't have a criminal history on. Okay. Nonetheless, you have the right to be represented by counsel. You have the right to have an attorney represent you at all of your court appearances, and the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. Do you understand that?
Yes, ma'am.
Did you want the public defender's office to represent you, sir?
Yes, I do.
Okay. The court will note that you're requesting representation through the office of the public defender. I'm also going to enter a plea of not guilty on your behalf. I'm going to remind you again that you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can carry the right to silence through your jury trial, and you have the right to a jury trial. You have the right to the presumption that you're innocent until proven guilty. You can maintain silence at trial, and they can't use that against you, or you can waive your silence and testify at your trial if you'd like. You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses to testify on your behalf. Do you understand those rights, sir?
Yes, I do.
You're currently scheduled for a probable cause conference before Judge Cynthia Ward on September 11th, 8 o'clock in the morning. You have a preliminary examination in person before Judge Ward on September 18th, 8:30 in the morning. Did you receive a notice to appear?
Yes, I did.
Let's see. Are you currently employed?
No, ma'am. I'm self-employed.
Self-employed how?
Landscaping. I got a landscaping business.
What's your phone number?
I don't have one.
You do not have a telephone?
Not at the moment.
Are you on probation or on parole?
No, not that I know of.
Oh, okay. You can address bond court counsel.
I'm asking the court for a PR bond with GPS tether, and if the court's not inclined, a low 10% bond. So Mr. Casada can go back out. From my understanding, he reports he's self-employed doing side landscaping jobs. It's like on the spur of whenever he gets to the job. So it's not consistent, but he does maintain employment for himself. He disputes allegations in this matter, Your Honor, as indicated earlier. With our not guilty plea, I just asked the court to take into consideration that this is an attempted home invasion, which I don't know what the allegations are exactly. The affidavit, but they raise questions to why it was charged and attempted. So I'd ask under the circumstances and his limited history based on the HAP third. I know you don't have a criminal history, but the oldest being 27 years ago, to take that in consideration. Mr. Casada just is a little upset of these false allegations, is what he reported to me. That's why there was that slight outburst this morning.
Mr. Casada, do you have another case pending right now?
No, this is all they gave me right here.
I have a bond recommendation from the prosecutor. They said that you're currently on parole, probation, or you have another criminal matter pending. I was not provided your criminal history, so I can't verify that, but I don't believe that I have no reason to believe that the bond recommendation is wrong. When I asked you, were you on probation or parole, you said not that you're aware of. But
No,
that doesn't mean that.
No, I'm not.
Is your office representing him on something else, Mr. Arnett?
I'm looking right now.
Judge, can I speak?
No, Your Honor. Not that I see of. Not that I see. No.
Yes, sir. Mr. Casada, you had something you wanted to say?
Yes, ma'am. I know I shouldn't say this, but
No, well, don't say it then.
okay. All right, I won't. My thing is this, ma'am. I have never ran.
Okay, that's enough. Martin, that's enough. You're getting yourself in. That's enough. We're all set.
Thank you. Bond is set in the amount of $2,000. Personal recognizance with GPS tether. You're not to be at the address at or near 206. I'm sorry, the address of 3900 Burnway Boulevard, apartment 306 or 206. You're not to be within 2,000 feet of wherever that address is. Do you understand that?
Yes, ma'am.
You're not to have contact directly or indirectly with a Joe Chambers. You need to report to all of your court dates on time. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use drugs or alcohol without a valid prescription. You're not to travel outside the state without prior approval of the court, and you must report to pretrial services within 48 hours of your release from custody. Okay?
What, you said 48 hours?
Well, technically, you need to report by Tuesday because they're going to be closed on Monday. Okay?
Okay.
Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Your Honor.
You're all set, sir.
Thank you. Have a good day. Have a good weekend.
Same to you.
Are you gonna have? Are we still gonna talk to you?
No, you're all set, sir.
So can I speak? Can I still have
You're all set.
word with you?
You gotta wait for the rest of the people.
I'll try. I'll see if I can first. I'll try.
This is the matter of the state of Michigan versus Shamar Biles. Counsel appearance, please.
Thank you, Your Honor. Good morning. Good afternoon. George Anid, Assistant Public Defender, on behalf of Shamar Biles, for purposes of arraignment only.
Are you Shamar Biles?
Shamar Biles, yes, ma'am.
It's Shamar, you said?
Yes.
Okay, Mr. Biles, today was the date that was scheduled for an arraignment. I do have a felony complaint here. The allegations are that on or about August 30th, 2025 at North Grand River at or near West Willow, Lansing, Michigan, that you allegedly committed the act in count 1 of controlled substance possession of methamphetamine and ecstasy. The allegations are that you did knowingly or intentionally possess methamphetamine contrary to Michigan Compiled Law 333.74032BI, and that's a felony with the maximum penalty being 10 years in prison and or $15,000 in fines. Do you understand the charge and the maximum penalty, sir?
Yes, ma'am.
Okay. You have the right to an attorney. Mr. Annette is going to represent you today for the purposes of your arraignment only, but you have the right to request the public defender to represent you at no expense to you, and you have the right to have an attorney represent you at all of your court dates and if you're questioned by law enforcement, okay?
Yes, ma'am.
You have the right in this matter to proceed to a preliminary examination. You are being charged with a felony. So you have the right to have that exam within 21 days of today's date, unless you waive that 21 days or the court finds good cause to go beyond the 21 days. You have the right at the time of the exam to require that the prosecutor put forth evidence that would establish that they have sufficient probable cause that a felony was committed, and then sufficient probable cause to charge you as the individual to have allegedly committed that felony. You are currently scheduled for a probable cause conference before Judge Cynthia Ward on September 11th at 8 o'clock in the morning. Preliminary examination is before Judge Ward on September 18th, 8:30 in person. Did you get your notice to appear?
Give me 1 second. Yes, I did.
Okay, and the purple sheet should be the instructions on how to log into her Zoom, okay?
Yes, ma'am.
Okay, again, you have the right to the presumption that you are innocent. So you're innocent, sir, until proven guilty. You can maintain your innocence, take this matter all the way through jury trial stage, and require the prosecutor first prove each element of the charge of controlled substance possession beyond a reasonable doubt. You have the right to be silent at your trial, and they can't use the silence to prove or imply that you are guilty, or you can waive your silence at trial and testify. You have the right to call witnesses to testify on your behalf. You have the right to see, hear, or question any witness called to testify against you. Do you have any questions about those rights?
No, ma'am.
Are you currently on probation or on parole?
Excuse me.
Are you on probation or on parole?
And another state, yes, ma'am.
In Philadelphia, Pennsylvania?
Yes.
Yeah.
What are you on probation for? I can't hear you.
I can't remember what I'm making patient for, ma'am. The cases are
You
so
can't
old.
Right
now, I can't
your
remember.
criminal history is so robust that you can't remember what you're on probation for.
Right now, I'm in a little pain. So right now, I'm going through pain of my health right now. So that's what's going on. That's why I'm saying I can't remember. My focus is on my health.
Okay, so you got something going on that you can't remember. Is this affecting you in any other way? Whatever is going on.
Listen, you asked the question about my probation. My probation probably was for a civil possession. And I can't remember. I'm in pain.
Okay, I recognize you're in pain. You're saying you need medical assistance. Is that what's going on, or?
Just got out of the hospital.
Okay, you just got out of the hospital. Okay. Do you have any other court cases pending at this time?
I think so, yes.
You think so?
Yes, ma'am.
In Pennsylvania or in Michigan?
I think in Michigan, ma'am. It's a business of. Are you hearing me, ma'am?
I can hear you. Does the jail have his criminal history? Because it wasn't provided to me.
I can bring it up to you, ma'am.
Yes, please. Thank you. Okay. Thank you. You can bring it up, please. Thank you. What is your home address, sir?
I stayed on the mission, ma'am.
I'm sorry?
I stayed in the rescue mission, ma'am.
At the rescue mission, you said?
Yes, ma'am.
Okay. Which one? The one on Michigan?
Yes, ma'am.
Okay. And do you have a phone?
Yes, ma'am.
What's your phone number? Are you employed?
Right now, ma'am, no.
What brings you to Michigan, sir?
I came here for employment for Cormar. Cormar reneged on a job opportunity, and on my way to go back home, the state of Michigan took my child from me and my girlfriend, and I've been stuck here trying to get my child back ever since. That's what I'm here for.
Okay, so and you're on probation in Pennsylvania, though, correct?
Yes, ma'am. But they know what I'm here for, so they'll owe me when I get back.
You have a pending family court issue with your child, you're saying?
Yes,
Here?
that's what I'm here. And that's what I'm in your state for. My child's supposed to sit back in Pennsylvania, and that's when I was going back home.
Mr. Nude, you can address the court on bond.
Thank you, Your Honor. I'm going to be asking for a PR bond today. The allegation in this case is not assaultive and does not indicate a threat to the public safety. And if anything, the allegation is a threat to himself. Mr. Biles has I believe, stent in his heart, and he plans or wishes to go to the hospital upon release, unless the jail takes him before, or if he doesn't get a bond. He was in pain this morning, but we did conduct a intake properly without any issues. He is currently homeless. He will be residing at the city rescue mission. He has a phone, he has an email, so we can get in contact with him. I believe that he will not be an issue, Your Honor. This is not a case that revolves around a victim or anything of that nature. So a PR bond would be appropriate. I don't have any information about in regards to failure to appear, flight risk, or anything of that nature.
He's got warrants in this state and other states, so that would mean that he is a flight risk.
He has warrants in this state.
That's exactly what I said. He's got warrants out of Eaton County, as well as out of state warrants. So a personal recognizance bond would not be appropriate. He's not able to provide me an address even in this state, or give the court reason to believe that he would stay in the state to handle this matter. I don't even know if he had permission to leave the state of Pennsylvania while on probation. I don't know that. But he's already on probation for possession. And then he's found here in the state of Michigan, allegedly in possession. He's got a warrant out of Eaton County for possession of controlled substance, as well as retail fraud 3rd degree, and he failed to appear in court. So a bench warrant was issued. So he'll be remanded on the bench warrant so that he can take care of his matters in Eaton County, and he will receive a $5,000 cash surety bond in this file with GPS tether. He's not to leave the state without prior approval of the court. He's not to possess firearm or a dangerous weapon. He's not to possess any drugs or alcohol. He's got to report to pretrial services within 48 hours of his release from custody. Do you have any questions about your bond condition, sir?
I'm not. I don't understand it, man. I'm trying to
I can repeat it for you, sir. Your bond is going to be $5,000 cash surety on this, but only after you address your issue in Eaton County. So I'm remanding you to Eaton County, meaning you cannot be released from custody. Once your issue is addressed in Eaton County, I will convert the bond in this file to $5,000 cash surety. Do you understand that?
Yeah. Yes.
And that's because you have a warrant for failure to appear. You don't appear in court. And then you're picking up the same types of charges, not just in this state, not just in this county, but other counties in this state. And then you have the same alleged conviction, obviously, the same conviction in the state of Pennsylvania, and you're currently on probation.
Nothing further, Your Honor. Thank you.
You're off that, sir.
And
On the record, in the matter of the state of Michigan versus Jquz King, I have file number 20-03434. Appearance, please.
Thank you, Your Honor. George. Thank you, Your
Good
Honor.
afternoon, Your Honor.
George Annette, Assistant Public Defender on behalf of Jquz King for purposes of arraignment only. Your Honor, we did conduct an intake this morning for the Public Defender's Office and rendering a plea of not guilty at this time.
Okay, you are Mr. Jquz King, correct, sir?
Yes, ma'am, I am.
Okay, I do have a misdemeanor complaint. It alleges that on or about August 21st, 2020, at the area of 704 West Kalamazoo Street in Lansing, that you allegedly committed the act in count one of domestic violence upon a Nadia Matthews, a resident or former resident of your household or individual with whom you had a dating relationship. And this was in violation of Michigan Compiled Law 750.812. The restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. And that is a misdemeanor, maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge, sir, and the penalty?
I do, Your Honor.
Okay, you do have the right to counsel. Mr. Nin has advised that you have requested the representation of the Office of the Public Defender for this purpose, so the court will note that. You have the right to plead guilty, plead not guilty, or stand mute. And Mr. Nin has also advised that you are maintaining your innocence at this time until the court will enter a plea of not guilty on your behalf, okay?
Understand, right?
You are presumed innocent until proven guilty, and you can carry that presumption all the way to jury trial. You have the right to have the prosecutor first prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to be silent at trial, and they can't use that silence to prove that you're guilty or imply that you're guilty. You have the right to call witnesses to testify on your behalf at trial or present evidence that you believe show a defense to this charge. And then you also have the right to confront and cross-examine in court any witness called to testify against you. You understand those rights?
I do, Your Honor.
You're scheduled for a pre-trial conference with Judge Stacia Buchanan on September 22nd at 2:30. You should have received a notice to appear and the Zoom instructions. Did you get those, sir?
Yes, Your Honor, I did.
Are you currently employed?
No, Your Honor, I am not.
How do you support yourself?
Actually, I lost everything coming to turn myself in.
You said you lost everything coming to turn yourself in. How does that happen?
I lost my apartment, my job, and because I had to turn myself in Kalamazoo. So I lost everything.
Okay, so you're not talking about turning yourself in on this case.
On all the cases. Yes, I am, Your Honor.
I'll elaborate. I can elaborate.
Okay. Yes, I'm not following. He just turned himself in today? I'm not following what's going on.
Well, my understanding is he had some old files. He turned himself in on when he was made aware of I believe a probation violation that stemmed maybe 4 or 5 years ago. Correct me if I'm wrong, Mr. King. Turned himself in, handled everything, got unsuccessfully discharged, but he's done with probation in Kalamazoo. He was found out about this, got transferred over here, and here we are, Your Honor, a 5-year-old case.
Okay, yeah. Well,
Understand.
just because the warrant sat for 5 years doesn't mean that it waters down the allegations. Let's be clear there. I do see on his criminal history that there was a probation that was revoked in Kalamazoo, that he was placed on probation, it looks like in 2018. I see that there was a 2019 case in the 3B District Court that was bound over to the circuit court that does not have a disposition, so that I'm inclined to believe that has not yet been resolved. It looks like there was a 2019 and also in Kalamazoo motor vehicle case, unlawful driving away, that he got 18 months probation. I don't know if that was connected to the one that he was just discharged or revoked from, because it does appear that the time frames are similar on that. And then looks like there was a in Kalamazoo on August 25th requested a warrant. You turned yourself in, sir?
Yes, ma'am, I did.
Or were you picked up on a warrant?
No, I turned myself into the Kalamazoo County Jail Sunday night around 10 o'clock p.m.
Okay, sounds good. And so that must have been the August 25th warrant requested on a 2022 file. And then there's this file that's been in warrant status since 2022. Nonetheless, you do have the right, again, to the presumption that you're innocent. You say you're unemployed, so you left your job so that you can turn yourself in on these warrants, is what you're indicating?
Yes, ma'am, I did.
And then, did you have a home address?
Yeah, I do have a home address now, yes.
What is that? Is he going to be serving time in Kalamazoo now, or what happened when his probation was revoked, counsel?
From my understanding, Your Honor, and this can correct me if I'm wrong, I think he just got a fines and cost it's unsuccessful discharge. With no further
No fines. I'm sorry, Ron. I have no fines, no costs on that. I'm actually discharged from everything. They just time served.
Okay. Due to the age of the case, as well as the fact that you turned yourself in on your warrants, court's going to grant a request for a personal recognizance bond. Bond is set at 500 personal recognizance. There is a no contact order in place for the protection of the alleged victim, Nadaya Matthews. Okay.
Yes, ma'am.
You're not to have contact directly or indirectly with her. You're not to be within 2,000 feet of wherever she lives, works, goes to school, or handles any of her business. You must report to all of your court dates. You should have received Zoom instructions, so you do have the ability to report to your next court date via Zoom, okay?
Yes, ma'am.
You do have the Zoom instructions, though, correct? I don't know if you confirmed that. You did get
Yes,
that?
ma'am, I do. Yeah.
Right. Also, while out on bond, you're not to travel outside the state without prior approval. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use alcohol or drugs without a valid prescription. And again, you need to report to your court dates. Do you have any questions at this time?
No, Your Honor, I do not.
Any additional matters for the record on this file?
No, Your Honor, thank you.
Thank you, sir.
Yep, have a great day.
Same to you.